Excessive drinking is responsible for more than 4,000 deaths in the U.S. among underage youth each year, which is why some communities like Crosse have created city ordinances to prohibit parents and adults from providing alcohol to minors. But a recent court ruling in Wisconsin could have major implications on those ordinances throughout the state. News 8's Sarah Tamer takes a deeper look.
Lisa, Wisconsin appeals court struck down an ordinance in Fond du Lac County that would prohibit adults from hosting underage drinkers in their home. The case comes after a man was ticketed last year for allowing minors to drink at his son's graduation party. The Wisconsin appeals court says city and county ordinances can't be stricter than state law. So what does that mean for La Crosse? Wisconsin Statute 12507 states a county or municipality may have a social hosting ordinance, but they must be in strict compliance with the state statute.
The County of Fond du Lac statute was not in strict compliance for a couple of reasons, one of which was the fine was more than the state statute indicated, and the Court of Appeals said because it was not in strict compliance, it was unenforceable.
There are a number of social hosting ordinances in La Crosse County. The ordinances in La Crosse and Onalaska are not in strict compliance with the state statute because the penalties are higher.
This is an area of the law that the state has exclusive control over. The legal issues relating to alcohol are something the state says we want to control. We're not giving you authority unless we explicitly state we'd give it to you, and you have to strictly comply with what we're telling you you can do.
For this reason, the Wisconsin Appeals Court struck down the Fond du Lac County ordinance. But Kolkmeyer says the statute is not exactly clear in terminology, leaving a potential gray area when it comes to the law.
I think a lot of it is tied up in the language that's used in the statute, and the ordinance attempts to help clarify that and create some very specific conditions that where this should apply.
Which Veenstra says gives cities and counties a reason to continue pushing for the ordinances.
Ask the legislature to modify the state statute to make it a little more harsh, perhaps, or to give them express authority to have a social hosting ordinance that is different than the state statute. That's one way they could get that power.
We received a statement from a La Crosse city attorney stating the following: the city will not seek judgments for pending social host citations, as it is likely the judgments would not survive appeal at this time. In La Crosse, a violation of the ordinance is a minimum of $1,000, whereas in the state statute it's $500.
Now we know this case is still in the Court of Appeals, but could it be heard by the Supreme Court?
Officials do say that this case will most likely be heard by the appeals court. Both attorneys are actually expecting that the appeals court will hear it.
All right, thank you so much, Sarah.